Good afternoon, everyone. Thank you very much for joining this webinar organized by the South Center. The South Center is an intergovernmental think tank of developing countries, which works across various policy fields, including public health and intellectual property. As a think tank of developing countries, we're deeply engaged in assisting our members in other developing countries in multiple areas, including in the response to the COVID-19 pandemic, in particular with regards to expanding access to COVID-19 medical products, including vaccines. So today we will be speaking about the issue of investment agreements and intellectual property rights and their impact on public health. While the inclusion of TRIPS measures in different free trade agreements remains a very deep concern for policy space to take public health related measures, there's many other areas that also require attention from developing countries where perhaps there's been less discussion. So this includes investment agreements that include intellectual property as a category investment. And these also may restrict the policy space that countries have then to undertake policies that are necessary at domestic level. So currently we're in a context where not only we're fighting the COVID-19 pandemic, but also concerns about the future in terms of also the new agreements that are being negotiated now. And so this is a good moment for reflection about where we are in the current context, what lessons can we draw from agreements that have already been crafted, looking at case studies, and also thinking about the future, about what can be done, drawing lessons from where we've been and where we are now. So in this context, we're going to hold a series of webinars on emerging trends related to free trade agreements that impact public health. And today we're focusing on investment agreements. So we have an excellent panel of scholars, and I'd like to start by thanking them for being with us. I'll be the moderator today. My name is Viviana Muñoz, and I coordinate the program on health, intellectual property, and development issues, including biodiversity at the South Center. So I will start by presenting our first panelist. Our first panelist is Cynthia Ho. She is from Loyola University, Chicago. She's the director of the intellectual property program at the Loyola University of Chicago. She teaches their courses in intellectual property, in patent law, comparative patent law, policy and healthcare, as well as civil procedure. And Professor Ho will be speaking to us on potential claims related to intellectual property and public health in investment agreements. So with that, Professor Ho, I give the floor to you for your presentation. Thank you very much.
Thank you so much for the kind introduction. I assume, let's see, you can see the slides?
Yes, we see your screen.
Oops, start from the beginning. Okay. So thanks so much for hosting this terrific webinar. There are so many issues, important issues to talk about. I think my goal is mostly to lay the stage for a lot of the other panelists who are going to go more in depth in particular areas. What I plan to do is to first do an introduction of international investment agreements, some basics of claims that countries should know about for these agreements, talk about how they've already expanded into IP, even though these agreements were not historically made for IP, and then talk about how we could expect some claims during COVID, even though countries are doing what they are trying to and need to do to protect public health. So to start from the beginning, international investment agreements, there's basically two types of agreements. In terms of international agreements, they are either bilateral, which is the majority of them, just between two countries, or they're free trade agreements, which is the norm these days. Free trade agreements like NAFTA and RCEP with an investment chapter. Now, the history of why we have these is important. I know I said that they weren't originally designed for IP, so it's totally different than the common story that we all know about TRIPS. Rather, the genesis for international investment agreements was decades before TRIPS. So it was the context of mostly newly independent nations who were really struggling to try to attract foreign direct investment, which they needed. At that time, many companies were reluctant to invest in terms of buying property or other investments because they were worried that these new governments weren't stable enough and might, for example, nationalize their assets. Or they would have no recourse if that happened because the legal government was new, or maybe they would have sovereign immunity. So in that context, the idea that came up was, well, we already have commercial arbitration for private businesses. Let's build an international system to provide a measure of security for these foreign companies so that they will invest. So it was designed to solve a very different problem that does not necessarily exist today. And it did succeed in some part, but it's interesting to note that the model, because it was based on private parties, it's just for arbitration of individuals, usually 3 arbitrators, not a judicial proceeding, and not with any appellate review that we're more accustomed to in most of our own countries, as well as even the WTO appellate body. Now, in terms of agreements that have investment claims, although they started back in the late 50s, 60s, they were really relatively few in number, even 20 years later. So in the early 80s, there were relatively few. And then as you can see, there was a huge explosion. And then more recently, there are fewer, not only because we now have over 2,000 existing agreements, but also in recent years, there's been a lot of criticism and critique of these investment tribunals as perhaps unduly getting into domestic sovereignty issues. But still, there are a lot of disputes. And this is a chart of known disputes. Unlike what we're used to in most judicial proceedings, sometimes these are not publicly acknowledged. But even based on what we know, there are still so many cases, many, many more than we're used to in, for example, the WTO context. And what is also very important to note, although it's not on this chart, is that for the most part, these disputes are against developing countries. The vast majority are big companies from high-income countries bringing suit against developing countries. Now, we should talk about what kind of claims exist in these disputes. Although each agreement is a little bit different, I'm going to talk about the overall similarities. Now, overall, these were designed to give equal footing for the foreign investors to domestic as step 1. Importantly, unlike what we may be familiar with in TRIPS, there wasn't language in the original agreements up until recent times for any kind of balancing between the owners of rights and the public. It's mostly just about promoting foreign investment, which is obviously important in terms of how these rights get interpreted. In addition to putting the foreign investors on equal footing in terms of no less favorable terms and treatment than domestic citizens, as well as other foreign citizens, MFN clauses, they provided special rights to foreign investors that were not available to local domestic companies. In particular, 2 claims that I think are really important to us today are claims of so-called expropriation, which could be a literal direct seizing of property, for example, to create a national park, or it could be indirect in that you have your property, but the value is decimated because of, for example, other regulations. And there's some actual IP context. It could be also you were denied a license, so your property is not as valuable, or nuclear energy is phased out, so the plant you bought to make nuclear energy is no longer valuable. That would all fall within expropriation without the government paying you. So in other words, the investment claim is, well, you took our stuff and you didn't pay us, so now we're going to sue for what we think you should give us in money. The other big type of claim is denial of what's called fair and equitable treatment. And this claim originally was fairly limited to outrageous conduct, but now it's been interpreted very broadly, and it is the vast majority of claims because it is so broad. There are many tribunals that will find in favor of the investor who claims that their legitimate expectations, as they define, were not met. So even if they don't have any evidence of lost profits, legitimate expectations can lead to substantial financial rewards. And on that issue, the outcomes are really important. These cases are very expensive. Even if a country who is brought with a dispute wins, the cost of defending is $5 million on average, and it can be even higher. The average cost of awards for a losing country can be about 500 million, but that's the average. There are actually cases where the amount is over $1 billion and some that are 2 billion. So the amounts are staggering, especially for developing countries. And especially because these claims can be made and won even when a country is under extreme duress. So for example, there were multiple disputes brought against Argentina during its financial crisis. So this is definitely something that countries should be concerned about. Also, in light of the substantial financial outcomes that are possible, this has a real chilling effect, especially on developing countries. As some of you may have heard, there were a lot of disputes by big tobacco, and one group of panelists is going to talk about this, suing countries about modifications of their tobacco packaging. A lot of small countries just gave up and they didn't enact good public policy because they did not want to risk the litigation. And it's not just small countries. Actually, Canada originally was going to be the first country to get legislation in this area. But after multiple companies in the US threatened to bring an investor-state dispute under NAFTA, they give up. So this is a major issue in terms of public policy. Now let's turn to IP claims in particular. So for years, there were no claims on IP, and it's not surprising since these investment agreements were not made with IP in mind. But the definitions of investment are pretty broad, and even without explicitly saying IP, in these initial cases, the tribunals did not second guess whether IP was an investment, which I think consistent with how most of us consider IP. It is a valuable commodity, even though it's intangible. So these initial cases were both won by the countries, but yet they have substantial lessons for us. In particular, in both of them, the countries were challenged for domestic laws that were consistent with international norms. So Philip Morris sued both Uruguay and Australia for regulatory norms that were consistent with the Framework Convention on Tobacco. Eli Lilly was sued for patent laws that invalidated Eli Lilly's patents under the so-called promise doctrine, which is consistent actually with TRIPS flexibilities that lets countries decide how to interpret requirements for patents. And in Canada's case, it was a requirement of what counts as useful. So Canada said, if you think that your invention promises something and you say that, you better have evidence to back it up. And it was designed to promote an issue that many public policymakers think is important, something that's called sometimes evergreening, where a drug is subject to multiple patents to keep extending and continuing the green money cycle for the company. So Eli Lilly already had the initial patent term on the molecular compound expire, and it was complaining that patents invalidated for subsequent terms was a problem, even though it's always been traditional patent policy that laws can change and your patent could be invalidated. So lucky for Canada, they got off, they just had to pay legal expenses, but it does present a problem in that the tribunal still said and considered that it was notable that Canada's countries were unique, which is totally contrary to what we know about in TRIPS, that the idea of flexibility is that each country can and should be able to design its laws when there are no explicit definitions for things such as what is new under TRIPS. The Philip Morris case against Australia went even further beyond challenging domestic laws and tried to make a claim that there was an investment claim for violating TRIPS without having any WTO input on whether that was true. So it turns out that the Australia case never got to the merits, but it is troubling, I think, that a non-WTO panel could be deciding WTO issues. Now, these are the only cases where IP assets have been seriously litigated that I think are really relevant. There's a separate case about Bridgestone and trademarks, but that's a little bit more complicated. There's also, I think one of the panelists is going to talk about, there was a threat of an investment case against Colombia with a precursor to compulsory licenses. But I think this gives you an idea of the possible threats for proper international claims or claims consistent with international TRIPS norms done for public health policy. Now, turning to the current issue of investment claims under COVID, do we have to be worried? The short answer is absolutely. Back in 2020, UNCTAD issued a warning when it was reviewing 2020 issues and said, all countries should be concerned that proper actions taken to protect public health could lead them vulnerable to an investor state claim. And they did suggest that maybe countries should be taking concrete actions to reform these agreements. There was also an article talking about cashing in on COVID, suggesting that there are a lot of firms who are suggesting to their companies and clients, hey, look, you can make money off of this crisis by suing companies. Importantly, the TRIPS waiver that's much discussed will not protect any country from these claims. Why? It's because the TRIPS waiver would only be a waiver from claims in the WTO TRIPS context. Investment claims are a whole separate regime, so this would not apply at all. Now, what could developing countries do beyond assert defenses, which do exist, but then you still have to litigate and pay for that? There have been proposals that have been made. The first is a complete moratorium of all investor state claims. That has been suggested. But considering there have been claims made, and I think there's over 50 just in 2020, that hasn't gone very far. Also, there was a proposal that at least COVID-related claims not be brought. So sort of similar to what we've been hearing about the suspension of TRIPS waivers, there has been a specific proposal that COVID-related investment claims also be suspended. But problematically, not a single country has endorsed this. And unlike the TRIPS waiver, it's not even discussed in the popular press. So I find that very problematic. So in light of that, what do we have to worry about? Well, let's see. There's a lot of possible claims The first is if the TRIPS waiver doesn't happen and countries take the action that some companies and countries suggest of issuing compulsory licenses for drugs and vaccines, that is highly likely to bring a claim for expropriation, possibly fair and equitable treatment. In addition, the TRIPS waiver itself could bring a flurry of claims from any company who's a foreign investor to a country that has one of these agreements permitting investor claims. Because they could all say, well, my investment is now invalid because you are not protecting my IP right. And even beyond IP, even laws that limit price control on drugs and medical supplies could also be a claim. Now, there are many, many more that impact public health. Even things like limits on restaurants in terms of capacity could give rise to a claim because the profits are limited. So there's a picture of a toll booth because there was actually one example in Peru where there was a suggestion that toll booths be limited so that the toll operators were not exposed to COVID. One of the private foreign companies suggested that they would bring a dispute. So the actions possible are quite extensive. In light of all these issues, I definitely think that countries should be seriously evaluating and arguing for at least a moratorium on COVID-related investment claims to ensure that they are not further behind as a result of proper public policy. There's lots more that we could talk about, but I appreciate your attention. And on this last slide, I've got ways if you want to contact me and other things I've written about TRIPS and also investor state. So thanks very much for your attention.
Thank you, Cynthia.
Thank you very much, Professor Cynthia Ho. And we've heard about the scope of claims of IP and investment and the challenges. A lot to cover, so I will try to summarize now. Just to highlight on the last point, a suggestion has come forth from our first panelist also for governments to consider taking forth the idea of the moratorium of COVID-related investment claims. So with that, we'll move on for now to our second panelist. And just to let our participants know that we will have some space for questions to be answered that you can be posing on the Q&A section. And we'll be addressing this after the panelists have finished their presentations. So our second panelist is Professor Federico Suárez. He is a trained attorney and currently professor at the Faculty of Law at the Externado University in Colombia, and a researcher at the Instituto de Estudios Constitucionales Carlos Restrepo Piedrahita. He holds a Master in Laws in International Commercial Law with International Law in Kent Law School and a Master's in Law in Human Rights and Democratization. He's also been a visiting fellow at the Transnational Law Institute of King's College in London. And he currently teaches international economic law, constitutional law, human rights law, international investment law, and transnational law. And Professor Suárez will be speaking to us on investment agreements, FTAs, and public health following COVID-19. So Professor Suárez, the floor is yours.
You're mute, Federico. We cannot hear you.
Yeah, thank you. Can you confirm me, please, that I'm...
Yes, we hear you now.
Thank you, Cynthia. Thank you, guys. Well, thank you so much, Viviana, for your presentation and for organizing this very great panel. I also want to thank to Vitor Ido, who is the person who also organized this, helped to organize this panel. And of course, I want to express my words of gratitude and admiration to the South Center, because during all these years, they have provided us light and strength to achieve universal, prompt, and effective access to medicines and to vaccines to all the countries from the Global South. And I'm speaking here as a Colombian, and who is coming from which is a country that is actually suffering a great deal because of the strong protection of patents and intellectual property rights that all the global economy has endorsed. So I want to express my admiration and gratitude to the Global South and to its director, Carlos Correa, for this incredible and important task, and of course to this team composed by Viviana and Victor. I also want to say hi to my co-panelists, Cynthia, Pratyush, Alebe, and my dear friend Nicolás M, and for to have this opportunity to share with you in this panel. Well, I'm going to present a paper that was written in two hands with my colleague and friend David Betancourt. He's also I see connected here, and he's now proposing some questions. And we work in a topic in relation with investment law and intellectual property law. And I'm going to present some of the basic ideas that we work in the paper that is going to be published this year in a special book that I have co-edited with other colleagues about poverty and inequality. And one of the topics that actually is indicated right now is that the intellectual property regime is actually one of the key drivers to promote inequality and to affect different kind of regions and people, and how investment law and intellectual property law has been drafted. It's a manner in which the developing countries and the largest corporations has been enriching itself thanks to this regime. So I'm going to make some brief explanations about this topic, and I'm also very much looking forward for your comments and questions. So I'm going to tackle these three topics. Basically, I'm going to make some comments about the intellectual property regime, and then I'm going to provide some empirical evidence against some patents, and I'm going to try to focus on the Imatini-Glibeck case in a brief comparison between India and Colombia, and how when you are referring to the Indian case, you will see how in India they forbidden the patent for Imatini-Glibeck, and in Colombia, by contrast, we are in the middle of a dispute with Novartis, the transnational that owns that patent, and that has used the intellectual property regime not at the moment in the investment dispute, but in the domestic level. So before I go into the proper arguments, I say that there is not a better moment probably in the world to discuss the proper foundations of the intellectual property regimes than the one that we are having now, because the entire world and the entire population has suffering a lot because of the norms that has been crafted, and also because of the very scarce productions of vaccines to tackle COVID-19. So this kind of panel that the South Center is organizing now is very well conceived, because there could be difficult to find a better moment to discuss all these topics and aspects. So the first idea that I would like to bring to you is that basically the WTO, as Cynthia has explained to us, has created a norm that protects investment rights and intellectual property rights, and this is of course a consequence of the manner in which the global supply chains of these resources has been created. Because at the very top of the global supply chains, we can see how the patents, the copyrights, and the intellectual property rights are directing the global supply chain. So whereas they have the knowledge, whereas they have the legal instrument to protect that knowledge, so they basically can distribute the consumption of the product in many other places. So what Amy Kaczynski explained, for instance, is that in the 1980s, 60 countries in the global south, they didn't allow patents in terms of medicines. But afterwards, when the WTO in the 90s and in the 80s were discussing the basics of intellectual property rights, the lobbying of the largest corporations and the lobbying of the developed world, they introduce all this protection in the international treaties that the developing countries must and need to enforce at the local level. So what they are also protecting here is a new way to value the companies and to value the investment. So by 1998, intangible assets were 85% of the total value of the companies, while tangible assets were worth only 50%. So what I would like to underline is that as foreign investment goes through intangible assets, and also at the fact that the companies, the most important companies that goes to the Standard & Poor's and to the stock exchange market are now valued in terms of the intangible assets. What the investment treaties and that the WTO regime aims to do is to protect those intangible assets that are part of the investment. So we have a very broad definition of investment in the investment treaties and the free trade agreements. And because of it, they include the intangible assets and the intellectual property rights that are behind all these things, without the consideration that it might have in terms of the public health, in terms of medicine, and of course in terms of the equitable access to health issues. So when we are referring to treaties, my second thought is, when we are referring to treaties, we are referring to intangible assets. And when we are referring to intangible assets, we are referring, of course, to intellectual property rights. And what they have been done in the intellectual treaties, in the investment treaties, is to protect those assets by those treaties. So what we have here is that, sorry, I'm struggling with the PPT. So what we have in here is that whereas the IP has had a stronger protection in the investment treaties and the WTO and the free trade agreements, this has been at the expense of the universal access of the global South nations to have access to the medicines. And secondly, there has been also an attempt to reduce the industrial policies that the global South nations can and aim to enforce. So what we are having now is a confrontation in the economic and the industrial realm, and also a debate in terms of the investment treaties and the norms that are enforced by the law. And what the developed countries have made is to work in both levels. They have enforced their industrial policies and the global architecture of production of medicines and so on. And in the other side, they have attacked the proper basics of the industrial policies that the global South nations have an aim to enforce. So what are the arguments sometimes in favor of patents? Usually the mainstream literature refers here to six arguments. It encourages innovation. Secondly, it promotes research and development. Third, it generates profits for creators. Fourth, it attracts new investors. Five, may be more valuable than tangible assets as well. And six, it helps to guarantee quality to consumers. Those are the very six arguments probably that we are hearing now opposing to the TRIPS waiver and to encourage the different phases of production in other developing countries. But what I'm trying to bring today is some evidence against those arguments, trying to think in a new model to promote both the industrial policies at the developing countries and also to promote a new and different model in terms of IP rights. So Katrina Pistors argues in her book, one argument that we have to consider at the moment is that one of the things that modify and that create wealth and that increase inequality are the patents. and she says that most investors, composers, and authors receive a very little return for their creativity. And the proper beneficiaries of the intellectual property rights are actually the largest corporations. And by monopolizing the pricing, the patent holder, by having the patent, they monopolize the price. And it also blocks other innovative products, medicine, and technologies to less privileged people in the development and less developed world. So there is a high risk that the state must compensate also multinational when they impose limits or restrictions on the exploitation of intellectual property, for example, in case of compulsory or parallel imports. Given the fact that those are monopoly, they have a really extended protection and so on. So I'm bringing this example in terms of access to vaccines. So we can have here how all the developing nations have made the greatest and the most important agreements with the most important corporations to have access to the vaccine at the moment. And we have the outrageous cases of Canada, which has secured 5 times their own populations in terms of vaccines. And so we have here how the developed world fund the vaccines, and throughout the intellectual property range, they are also increasing the profits of the multinationals that are, of course, producing this thing. So here, in terms of value of the shares of the multinational, we can have here how all the market from the multinationals is worth like $2.7 billion in terms of the industry, and we are having here all the list of the main multinationals and how they are increasing their wealth during the present crisis of COVID. So I have here the data of Pfizer and Moderna profits and agreements, and they are they have reached 780 million in terms of vaccines in terms of Pfizer, and they are having revenues in terms of 21,500 million for Pfizer, and in terms for Moderna, $90,600 million in 2021. So we are having where we are experiencing at the one hand important lack of medicines. At the other hand, we are experiencing how the intellectual property regime is increasing the wealth and the revenues of the largest pharmaceuticals companies. And we have the same thing with Johnson & Johnson and with AstraZeneca. We have here how they aim to receive $10,000 billion just with the vaccine in terms of Johnson & Johnson, and AstraZeneca is aiming to receive at most like $3,000 million. So on the one hand, we have many arguments saying that it helps to provide or to have universal access, but we have seen the two different things. On the one hand, they don't provide universal access in a prompt moment, and on the other hand, it also promotes the concentration of wealth and the increases of profits and revenues for the largest corporations. So I'm going to go fast to the imatinib and Glibe case to conclude my presentation. So I just want to say that in 2013 in India, the Indian Supreme Court rejects Novartis' appeal and refers that according to Indian patent law, the beta polymorph of imatinib mesilatab cannot be patented under Section 3 of the Act. So Novartis aims to enforce the patent of imatinib Glibe case at India. This is a medicament that it's against cancer's problem. So we have how India, by rejecting these kind of claims, they reject, of course, the attempt of Novartis to enforce this patent. But we have the other part of the story. In 2006, Colombia signed the bilateral investment treaty with Switzerland, and because of that agreement, the Novartis company also have the access to ISDS jurisdictions. And in 2012, they received the patent of the Council of State in Colombia. But then afterwards, the civil society and the Minister of Health in Colombia, they aimed to adopt a compulsory license based on the exceptions given in the TRIPS agreement. So in the Article 31. So the health minister attempts to enforce a compulsory license, but the diplomatic pressures of both of the United States and Switzerland were against the imposition of the compulsory license. So the decision that the Colombian government adopted at the moment was that instead of adopting a compulsory license, they decided to declare the medicament as public interest. So it reduced the price of the medicament in terms of 40% of its original price. But however, as it is written as well in some further research of the proper Minister of Health afterwards, it demonstrates how even with the declaration of public interest of imatinib case, they weren't able to actually reduce the price because as Novartis controls the supplies and the offer of the medicament, they didn't were affected in terms of the revenues and in terms of the decision of the Colombian government to reduce the price of the medicament. And afterwards, because of the lobbying and the pressure of the US and the multinationals and Switzerland, the Minister of Commerce of the proper Colombian government, they reject the previous legislation that they have enacted to adopt further measures in terms of public interest of the medicaments in the country. So Novartis now, they are suing at the domestic level the decision that declares the public interest, and they are going to the Council of State, which was initially the domestic authority that protects the patent of imatinib beta crystal. So what I want to conclude now is that it is necessarily to rethink the patent system as a whole and to devise different strategies to regulate and reduce cost of expensive drug products for developed countries that are most affected by transnational interest drugs. So thank you so much for your attention, and excuse me if I take a few minutes more. Sorry, thank you.
Thank you very much, Federico, for bringing us through again on the relationship of patents, prices, and reduced competition, and how this affects access to medicines, and clearly also the example of the challenges of using the TRIPS flexibilities with regards to access to medicines with the Colombia case of imatinib, where there was a strong effort from Ministry of Health, but with the pressures exerted externally, it was difficult to move forward. So for our next panelist, I'd like to introduce Pratyush Nath Upreti. Pratyush is a postdoctoral researcher at the Faculty of Law of the University of Helsinki. He is a lawyer admitted to the Nepal Bar Council. He completed his doctoral research at Sciences Po in Paris at the intersection between intellectual property and international investment law. He's also a Transatlantic Technology Law Forum Fellow at Stanford Law School. And he's also previously been a visiting research fellow at the Max Planck Institute for Innovation and Competition in Munich, as well as the Center for IP Policy and Management at Bournemouth University in the UK. He also holds a bachelor's from University in India, from KIT University, as well as an LLM from Maastricht University. So thank you very much, Pratyush, for joining us, and I'll give you the floor for the discussion with regards to reconceptualizing definition of investment, the role of national and international IP law and policy. Thank you.
Thank you, Viviana. I'm trying to share my slides, but
if you look at the share screen bottom,
yeah,
perhaps if Federico, you can check if you have closed it. Oh, yes, the share screen is closed. If you have any difficulties, yes, if you have any difficulties, you let me know. I can upload it for you, Pratyush.
Yeah.
Just give you a minute.
Yeah, I think could you please upload? I just can't. There's something wrong with the.
Okay, so I'll find your presentation. I'll upload that. Can you see that correctly?
Yeah, yeah.
Yes, please go ahead. You can let me know when you'd like me to move.
Okay. First and foremost, thank you so much, Viviana, for your kind introduction and South Center for organizing this important event. So what I'm going to do briefly is I'm going to raise two important points. Next slide. So the first point is, on what grounds state justify COVID-19 related public health measures against the breach of investment obligations? Second, redesigning investment treaties. What are the policy considerations moving ahead? Next slide. Yeah. So on what grounds state justify COVID-19 related public health measures? I think given the nature of pandemic, there has been and there will be more regulatory response to deal with COVID-19 measures. So in exercising these regulatory measures, state might breach investment obligation under international investment agreement. That is mostly breaches of expropriation, fair and equitable treatment, legitimate expectation of investors. So what are the potential defense that state might argue in case of potential investor-state arbitration related to COVID-19? So if you look at the international investment agreement, most of the international investment agreement do have this general public policy exceptions, right? And for that matter, let's say India, Brazil 2020 BIT, which is not enforced, do have a general exception provision. And state would argue that the measures taken in relation to COVID-19 will fall under public policy exceptions. And the third option or defense would be right to regulate. Under CETA, under Article 8.9 talks about reaffirms the state regulatory right to protect public health, public interest in general. And the fourth defense would be a doctrine of police power, in a sense that to some extent, Philip Morris versus Uruguay has reaffirmed that state regulatory power to protect public health as an essential and important principle under customary international law. And the fifth defense would be security exceptions. And for example, if you see RCEP, the language of security exception is much more broad than other investment agreement. There's a reference to national emergency. So one state would argue that perhaps public health emergency would qualify as a national emergency. But in most of the investment agreement, the security exception language is much narrow. It links to the war or military intervention. So these are the 5 general defense where state might argue against investor claims. But I'm not very confident that state will succeed in this defense for many reasons. And I might lay down a couple of reasons. I think first and foremost is looking at the arbitral tribunal practice of last 15 years. And it seems to me that the arbitral tribunals decision-making is more inclined towards protecting investors. And as Cynthia has already mentioned, the very rationale of intellectual property protection and investment under international investment law is quite different. So this is one reason. And perhaps there are many, for example, lack of inconsistent decision-making by the arbitral tribunal will not allow to get a result which is more favorable to its states. And also the fact that arbitral tribunal do lack this balancing mechanism. So in that context, perhaps it may not be, the decision might not be favorable to states. And also keeping in mind that ISDS is also not about winning. At times it is also about threatening states to change regulatory system. And as we have seen from 2 previous speakers, that through ISDS, investors or multinational company can threaten states, particularly developing countries, to change their policy. So what are the other options if not these 5 options? Next slide, yeah. So in my view, the best practical solution to mitigate the risks of ISDS litigation in relation to COVID-19 measures or in relation to IP-related COVID-19 measures is use Articles 57 and 58 of Vienna Convention on Law of Treaties and suspend the operation of investment agreement, the existing investment agreement, or part of existing investment agreement. For that matter, it could be investor-state dispute settlement chapter, right? And that is more practical. And why I say this is more practical, because this morning when I looked at the TRIPS waiver proposal, and I think more than 120 countries has supported TRIPS waiver proposal. So assuming that those countries who are supporting TRIPS waiver proposal have international investment agreement, right? And given that they have international investment agreement or bilateral investment agreement among themselves, the best way to mitigate the risks of investor claims in ISDS is to engage in bilateral agreement on IP waiver or COVID-19 related measures as a subsequent agreement under Article 31(3)(a) of BCLT. So what does it does is, given the fact that there are so many existing investment agreement, and if waiver proposal is made as a subsequent agreement to the existing investment agreement, then state will make a defense that, or in other words, state investor cannot claim that IP related COVID-19 measures breaches expropriation or violate their legitimate expectation. So in my view, these are two practical solutions and immediate solution which would require, because moving ahead, we might change the language of BIT, but how do we address the current existing BIT itself? And given 120 countries are serious towards IP waiver COVID-19 proposal, I would be surprised that they would be reluctant to have this bilateral agreement on IPR waiver and to put it as a subsequent agreement under Article 31(3)(a) of BCLT. So these are two important and most practical solutions moving ahead. Another slide. Yeah, and what is more interesting is in 5th of May 2021, Canadian released their model BIT, and what was more surprising, perhaps for me, was they have used the language of any waiver or amendment of TRIPS agreement in exception to expropriation clause. So generally, under international investment agreement, under investment chapter, under the clause of expropriation, compulsory license, among others, are excluded for investor to claim as an expropriation. So in this model, Canadian BIT, there's a reference to waiver in relation to TRIPS. So if you read this Article 9, Para 6, one would argue that this waiver is a reference towards TRIPS waiver provision. So this is a way to move ahead in terms of model BIT, and I think Canadian approach is right approach and very timely to address COVID-19 related measures, particularly the suspension of TRIPS provision. Yeah, so now second important point of my presentation is, I mean, in previous slide, we looked at the how to address the COVID-19 related ISDS claims. But moving ahead, I firmly believe that the one way to mitigate the risks of IP-related investor-state arbitration is to redesign the investment treaties. And for quite a long, I think, developing country has been at the receiving end, and they has been threatened through investor-state arbitration, and they have been forced to change national laws. So one way to look at is to redesign the treaty, and for me, the way to redesign the treaty is to understand what is the role of domestic law in investor-state arbitration, and before moving the role of intellectual property, national IP law and practice in resolving the tension between IP and ISDS, it is important to understand that the international IP framework allows states to enact laws to match their own policy prerogative, that that is through flexibilities, exception, and limitations. So at national level, legislature enjoys a wide margin of appreciation in relation to IP issues. So national countries our national practice can shape the intellectual property policy and shape the IP regime in that specific country. So we know there's an importance of a national role and a national law, particularly domestic practices in building the IP system. So for me, the best way to mitigate the tension is to bring those national exception and limitation and practice into the adjudication of IP and investor-state arbitration. And in my recent article in ISC, I used what is the role of national IP and international IP in reconceptualizing the notion of investment. And I build on the argument made by Professor Correa in 2016, very influential article on intellectual property rights as protected investment, how open are the gates. So next slide. So in this article, I developed two approaches in which we could bring the national IP practice and into the adjudication of IP and ISDS dispute. So in all international investment agreement include IPR in definition of investment, and the starting point of tribunal assessment of jurisdiction is to see whether dispute arises out of investment or not. So basically, to qualify as at the jurisdiction level, first you need to establish that intellectual property is mentioned in the definition of investment, and there is a separate investment assessment done by the tribunal based on arbitral tribunal decision. So if you look at the international investment agreement, there are two kinds of definition of investment. One is asset-based definition of investment. Second is enterprise-based definition of investment. So first, asset-based definition of investment or assets-based approach of investment. So basically, under asset-based approach, investment is defined as investment shall include every kind of assets, in particular copyright, patent, etc. And so this is one type of asset-based approach where intellectual property is just listed in the definition of investment. So the other style of asset-based approach in defining investment is, so there are certain characteristics of investment must be fulfilled. For example, a commitment of capital, resources, and expectation of gains, profit, or assumption of risks. Once this is done, within that definition of investment, intellectual property is included, which are recognized at the national law. So this is one example of RCEP. So the second is enterprise-based definition of investment. So I think in 2015 and 16, two developing countries, India and Brazil, took a very radical approach, and I think which is the very correct approach in order to regain the sovereign authority in terms of regulation is to reconceptualize the definition of investment. So Indian model BIT started using this enterprise-based definition of investment, that is investment means an enterprise constituted, organized, and operated in good faith by investor in accordance with the law of the party. So after this, there is an exhaustive list of asset that an enterprise may possess, which includes intellectual property. And in addition to this, model Indian BIT explains the meaning of enterprise, that is any legal authority constituted, organized, and operated in compliance with law of party that must have real and substantial business operation in the host states. So the
Pratyush, I'm sorry, we're going to have to start wrapping up, please.
Yeah, so the second approach is enterprise-based definition of investment. Next slide, please. Yeah, so the best way to reconcile the tension between IP and ISDS is by providing, laying down the condition for access to dispute settlement by redefining the content of investment. And there are two approaches. Next slide would be my last slide, I guess. The first approach is to to add exception and limitation to the definition of intellectual property under investment. So what will happen is that when exception and limitation is included in definition of intellectual property under the general definition of investment, so when tribunal is assessing whether intellectual property is investment or not, they need to take into account the national practice and exception and limitation. So here exception and limitation should be understood in broader sense, not only including fair use or exception and limitation under TRIPS, but also the decision of domestic courts. So in this way, we can reconceptualize the notion of investment. And my last point is the second approach is to include negative definition of intellectual property in definition of investment. And I think these are two basic suggestions which I have proposed in my article. And I'm happy to have further discussion. And I'm sorry that I couldn't keep my time. Thank you so much.
Thank you, Pratyush. I'm sorry to cut you on time, but we will anyway share with participants the slides, and they'll have contact detail if there's interest to further look at some of the works you've done on the issue. So I'd like to now pass on the floor to Alebe, Linhares, Mesquita, together with Vivian, Daniele, Rocha, Gabriel, who will be discussing in particular revisiting the case of Philip Morris versus Uruguay, which was a very interesting WTO case looking at the tobacco packaging measures in light of their international investment obligations and what can we learn about this case. So Vivian is an international trade lawyer. She also holds a PhD and master's in international law from the University of Sao Paulo, and she was also working at the School of Economics of the Getulio Vargas Foundation. Alebe Linhares Mesquita is an attorney at Microsoft Germany. He holds a master's degree in international and comparative law at the University of Sao Paulo and an LLM in intellectual property and competition law from the Max Planck Institute on Innovation and Competition. He's also been associated to the Federal Institute of Intellectual Property of Switzerland, as well as a visiting researcher at the World Trade Institute. So Vivian and Alebe, I have the pleasure to give you the floor. Please go ahead.
Okay. Good afternoon, everyone. I would like to firstly thank all the team of the South Center for the invitation to be part of this discussion. And Alebe and I were here to contribute with the discussions about the important intersection among investments, intellectual property, and public health. And we have organized our presentation according to the questions addressed by the South Center before today. Our presentation has as a starting point our brief paper published by the South Center about the investment dispute Philip Morris versus Uruguay, when we analyze how and to what extent states can adopt tobacco control measures without violating their international obligations to protect investment and intellectual property rights of foreign investors, such as those embodied in the trademarks of tobacco companies. This work contributed to discussions on how to address the conflict between foreign investments and IP rights and public health precepts. And despite the paper had focused on this specific investment arbitration case, we state some guidelines that can be applied even to the situation we face nowadays, that is the COVID-19 and the compulsory licensing. In this way, we brought some practical solutions to negotiators and policymakers looking at future cases based on what we learned at this case. Concerning to the first question that you sent to us, how do investment agreements relate to intellectual property and what are their impacts on public health, particularly access to essential medical products? At first, it is important to highlight that the starting point in the intersection between IP and foreign investments is materialized through the inclusion of intellectual property in the definition of investment in international investment agreements. Normally, as my colleagues have highlighted before, the definitions of investments are broad and involve tangible and intangible property rights. And in the intangible property rights, it may be discriminated IP rights. In this sense, an IP right is an investment and may be affected mainly by regulatory measures that might have a negative effect in a property right. The modern concept of expropriation is generally broadly construed as a protection provision, and investment agreements do not only include direct and full taking of property, but also indirect expropriation. That is, measures that do not directly take investment property, but which interfere with the use of property, depriving the owner of its economic benefits. A preliminary observation is that the determination of whether a measure is an indirect expropriation must be made case by case. And the mere fact that it may have an adverse economic effect on an investment standing alone does not establish that indirect expropriation has occurred. For instance, in the Philip Morris versus Uruguay case, Philip Morris argued that the Uruguayan control policies based on the Framework Convention on Tobacco Control regarding graphic health warnings and the single presentation of tobacco trademarks violated international investment commitments as an indirect expropriation. But the investment tribunal considered that it did not characterize a substantial deprivation of the value, use, and enjoyment of the investment, since the claimants still had significant returns on their investments in Uruguay. And another investment right that is commonly provided in investment treaties is the fair and equitable treatment, normally related to the violation of legitimate expectations of investors. In the Philip Morris versus Uruguay case, the investors argued that Uruguayan measures were arbitrary and violated legitimate expectations. And the arbitral tribunal understood that the measures were not arbitrary because they have been implemented for the purpose of protecting public health, a connection between the objective pursued by the state and the goal of the measures. And there were no legitimate expectations that public health measures would not be adopted. From the state's point of view, the inclusion of intellectual property in the concept of investment has determined a paradigm shift in the international regulation. As intellectual capital importers, during the negotiations, developing countries generally accept higher IP standards in FTAs and BITs to obtain federal concessions in other areas, notably agriculture. In this sense, capital importing countries, especially in the global south, might be pressured by softened internal policies to attract investments, a possible regulatory race to the bottom. This might have some negative aspects. From a domestic point of view, it may also trigger policy or regulatory chill and the discouragement for developing countries to implement public measures in favor of fundamental rights, such as the right to health. And given that intellectual property might be incorporated into a BIT through its definition of investment, countries may not adopt measures aiming at facilitating access to essential medical products, for the fear that these measures might be challenged in an investor-state dispute. Investors can directly challenge public health measures through investor-state dispute settlement, arguing, for instance, indirect expropriation or a violation of the FET, the fair and equitable treatment. This can lead to a deterrence effect, and those countries can lock themselves in higher levels of IP protection that do not reflect their development stage nor the current crisis, such as the pandemic, with potential effects on innovation and access to medical technologies. In this sense, our concerns, transposing our concerns into policy recommendations for developing countries, negotiators and policymakers to try to neutralize the negative effects on public health, we propose that first, countries have to start adopting modern BIT models or updating old ones with new elements aimed at rebalancing the rights and obligation of the parties concerned There must be an equitable design of foreign investors' rights and the host state's exceptions, that is the flexibilities presented in the BITs to these rights. Developing countries, negotiators, and policymakers should design their international investment agreements with clauses that safeguard their policy space. And this can put in practice by adopting provisions in 3 different regulatory levels that we classify then into general, intermediary, and specific. We propose that the general provisions, they are like adoption of clearer and less vague provisions on the state's right to regulate in the public interest might be avoid future concerns and disputes. As we can see, for example, in the Netherlands BIT model from 2019 that adopts clear language to safeguard the host state's right to adopt measures to protect legitimate public interests. According to Article 12.8 of the Netherlands BIT model, measures that are enacted in a non-discriminatory manner and applied in good faith to protect public interests, such as the protection of public health, safety, environment, or public morals, social or consumer protection, on promotion of cultural diversity, do not constitute indirect expropriation. This example shows that even traditional capital exporting countries are recalibrating their international investment frameworks to ensure that their states' rights to regulate. The intermediary level that we propose here corresponds to the exclusion of measures adopted to protect public welfare from indirect expropriation. The Comprehensive and Progressive Agreement for Trans-Pacific Partnership, also known as the TPP-11, in letter B to Article 3 of Annex 9B, specifies that some types of regulations applied in a non-discriminatory measure to protect legitimate public welfare objectives, such as public health and environment, cannot be considered indirect expropriation. To us, this is—
Sorry, can I just ask you to start wrapping up, please? Thank you.
And finally, we have our specific level here. That is the exclusion of specific measures from the investor state arbitration. For instance, the CTPP also innovated in excluding tobacco control measures from the investor state dispute settlement, and the explicit exclusion of compulsory licensing from the concept of expropriation, such as the CTPP and the CETA that provided the Philip Morris versus showed that and he realized when there's a clash
we're losing the connection
between the public and private interests, such as in the case of public health. So these measures can safeguard and prevent question before an international state arbitral tribunal. So these are our proposals. Now Alebe will address.
Sorry, Vivian, I think the communication has cut, but we heard that you were passing the floor to Alebe. So
Yes.
Alebe, I give you the floor, and just please ask you, sorry, the time is coming short. If you can keep it concise, and perhaps also then we can share the reference to the full document, because I think you have a lot of very concrete proposals there that's worth also for participants to read further. So please go ahead, you have the floor.
Yeah, exactly. So thank you very much. And Vivian, I think she just had a problem with her internet. But then in the end of the presentation, I would like just to present actually the concrete measures that the negotiators and policymakers, they can actually adopt in order to solve, let's say, what they could do in case an investor challenges a compulsory license under the framework of the investment agreement. And as what Vivian was saying, it's going to really depend on the case by case, and the BIT and the arbitral tribunal have to decide based on these 3 regulatory levels that we have of these types of provisions that she presented, whether general, intermediary, or specific. One proposal that we thought that it could be very helpful was really like to adopt an investor state dispute settlement exclusion for example, for a pandemic or the COVID-19 measures, such as a compulsory license. This type of exclusion has already been adopted, for example, against the tobacco control measures for ICDC in the CPTPP, as Vivian has shown. So there's something that could also be adopted in the investment or the investment agreements. Another concrete solution is also, if it comes to a dispute, the Appeal Tribunal, he can also apply the principle of systemic integration enshrined in Article 31.3c of the Vienna Convention. So these provisions require actually adjudicators to take into account any relevant rules of international law applicable in relation of both parties. So although, let's say, the TRIPS flexibility to adopt a compulsory license is not foreseen, the whole investment system, the adjudicator, by the time that is trying to solve this dispute in order to solve the case, it could also interpret these obligations in light of the flexibility that he has on the TRIPS agreement. And then another point, it's also the adoption of side letters for post-agreement phases, or also the adoption of provisions confirming, for example, the Doha Declaration, the TRIPS and public health, or really the provisions that really exclude, for example, compulsory licensing from the concept of indirect expropriation. I think this would really certainly give more legal certainties to both parties that are in the investment relations. I think these were the most concrete proposals that we had. We are much looking forward for the discussions with the group, and thank you very much for all the attention and all the time here.
Thank you, Alebe. I'd now like to give the floor to Nicolás M, who will be our last speaker. He's Professor of International Law at Universidad Andrés Bello in Chile. He researched on international economic laws, particularly international investment law and policy, and he's previously teaching at Durham University, the Institute of Global Law and Policy at Harvard Law School, as well as University Externado, Colombia. So Nicolás, I'm happy to give you the floor as our last participant for this panel. Thank you very much. The floor is yours.
Thank you, Viviana, and thank you very much to the South Center for the invitation, to Vitor as well, and to all the previous speakers for laying the floor, I think, for what has been so far a great conversation. So, and I actually gonna push on 3 points that I think are very important. And as Cynthia did, I'm gonna start with history briefly. I think it's important to keep in mind the historical context and framework of both the TRIPS agreement and investment treaties. So the two regimes, if you look at them, if you look at the history of them, are not the outcome of global South countries or countries in general asking, to facilitate the creation of technology or the facilitation of investment, but rather was the demand of investors. In the case of investment treaties, particularly oil companies in the 1950s and 1960s, because of the decolonization context and the Cold War, they were afraid that the business model was at stake. We need to remember that many global South countries thought that the best thing to go when it comes to their natural resources at the time was to nationalize those resources and create state-owned companies. I mean, it's not our point, the point whether that was a good or bad policy, but the question was that investment treaties were a response to that threat, to the threat that companies like Shell felt to their business model. It's not that different when it comes to TRIPS. TRIPS is not the outcome of global South countries asking for a better system, so there was a technology, technology would fly from the north to the south, but it was actually the demand of laboratories and software companies that particularly convinced the US administration to push forward in the Uruguay round, to create a system or a regime like TRIPS. So it's not like countries like India, Brazil, or Argentina were asking the Uruguay round, we need a better system, we need a stronger protection of IP. So technology is gonna come to our countries, but rather the opposite. I think this is important to bear in mind, not to lose the connection that there is between intellectual property, investment, foreign investment, and development. So we can think about, the main problem here being sustainable development as opposed to protection of IP and investment. And if we do that, if we recenter the discussion, it looks slightly different because foreign investment is a way, foreign private investment is a way in which countries can obtain technology, capital, resources that otherwise they wouldn't have. But there are other ways, including aid and transfer of technology. So if we locate ourselves in the 1950s and 1960s, what the Global South was demanding was no foreign private, more for private investment, but rather transfer of technology. Who were the actors opposing that position? Were, for instance, the International Chamber of Commerce and the investors that were promoting investment treaties. So it's interesting to keep in mind all the different options that were out there and how players were, promoting one or the other. So if we think about it, transfer of technology is another way in which countries in the Global South can obtain that technology. And it's important to keep in mind that the US administration back then and the World Bank were not completely against this. In fact, Truman's 4-point program was not against transfer of technology, but the International Chamber of Commerce was very critical of that particular point. So I think this gives us a little bit of the context of when we're talking about the connection between investment agreements, TRIPS, and development. Both investment treaties and TRIPS have a particular means to promote development, which is to protect property. The idea being that by protecting property, you would encourage investment and innovation. But as Federico was saying, this is not so obvious or clear. I think after more than 20 plus years of neoliberal policies, there are question marks. So we're not entirely sure that this works. And in fact, in situations like the COVID-19 pandemic, it seems to be actually the opposite. It seems to be, judging from the presentations of all the previous speakers, it's the opposite. It's backfiring. We actually have less sustainable development because of the investment treaty and TRIPS. So this doesn't mean that we should not protect property, and I want to be clear about that. It just means that maybe the distribution of benefits, costs, and risks that are the outcome of these treaties and TRIPS is not the ideal one, it's not efficient, and we may want to revisit that. So that's my the first point I wanted to make as a sort of a general remark. I think the second point, it leads also to something that Cynthia mentioned, and then others touch on as well, which is that when we're talking about international investment disputes, ISDS practice, if you want to put it like that, the tension is not only between the private and the public, or between foreign investor rights and the right to regulate. I think what Cynthia was mentioning is very important to keep it in mind. There's also tension between global standards, global consensus, the way we globally accept certain things to be done, and the way that can be, locally implemented, or other local, more specific country proposals. So both, if you look at the decision, both in Eli Lilly and Philip Morris, you see that the two investment tribunals are checking the particular laws of both Uruguay and Canada to see if those laws are consistent with what we globally understand to be the right way to deal with intellectual property. So this is quite interesting because, as Cynthia was saying, Canada's regime is unique. The fact that it's unique is a bit of a problem for an investment tribunal. And if you look at that regime, if you look at that dispute, the arbitrators accepted to get expert witnesses from IP experts to see whether this was not a bit of a deviation from the normal. So what investment tribunals are trying to look at is not just the tension between the private and the public, but also to check that countries are not deviating from global standards, from global consensuses. If you are within that global consensus, you are fine. But if you are outside of it, then that might be a problem. Of course, this creates a political economy that it puts global South countries in a worse position, because normally global North countries and the big firms, they are the ones who set the global standards, aren't they? Whereas for countries in the South, they might want to be more strategic. They might want to be more experimental to see if they can adapt those rules to their situation, to their context. And this, I think, is when it gets to trouble. It's not a coincidence for me that the dissenting arbitrator in Uruguay and Philip Morris in Uruguay, sorry, was kind of, let's say, more skeptical about the measure that Uruguay implemented. That was not the one recommended by the WHO and the Pan American Health Organization. That particular measure was the most problematic for him, you know, and it's perhaps because it's the one that Uruguay thought it was the right thing to do, as opposed to the global consensus. So I think this is quite important. There was a question in the chat box about generics, and I think that leads us to, you know, and I think Pratyush is right that domestic practice is important, but we need to keep in mind that it's not the same domestic practice in the north and in the south, and it's how investment tribunals are gonna frame and think about these things. When it comes to generics, when it comes to, you know, innovative industrial policy that is not recognized globally, I think global south countries will have more problems to frame that as measures that are acceptable. And if you look at some interviews that have been conducted to arbitrators, I think, you know, either let's say consciously or unconsciously, they reflect that they have this preference for the global. And there are implications for that I think we need to keep in mind. So yes, this was the sort of second point I wanted to make about how an investment tribunal may look at these things, regardless of all the of treaty text and the exceptions in treaty text. I think we need to keep in mind also the mindset that arbitrators bring to the conversation, the sociology of arbitrators, of what ISDS is all about, and the history of ISDS, how ISDS was implemented. And of course, ISDS is a mechanism to protect property with the hope that it's going to promote development, that it's going to help technology to go from the north to the south. But that's a hope. We don't know if it works like that. But we know that property is being protected and awards are being rendered, and sometimes countries need to pay a lot of money. So the connection with development is a little bit weak, if there is a connection at all. And I think there is a problem, particularly the countries that are in need for more sustainable development. As Federico was saying, are countries that are at the moment, for instance, don't have vaccines to inoculate the population. And the third point I wanted to make relates to ISDS intellectual property protection and COVID-19 and the pandemic. So I think you all noted, I mean, Cynthia, Pratyush, Alebe recently, just a second ago, sorry, you all noted the importance of a moratorium, not only implementing, or not only a waiver within the TRIPS context and the WTO, but also in the investment law world. But the question, and somebody put that question in the chat, is where do you take that proposal to in the international investment treaty world? Because there is, when it comes to trade and intellectual property, a WTO that is not only about protecting TRIPS, that is not only about ensuring that there is no discrimination when it comes to trade, that is not only about global standards, but it's also about diplomacy. Members of the WTO meet regularly and discuss questions. There is a possibility of meeting and issuing a waiver, because the trade regime, and I'm not a big fan of the WTO, but still the trade regime has a diplomatic element in it that has not been eliminated when the WTO was created, but perhaps even the opposite. From the GATT to the WTO, that diplomatic element is still there. It's not the same with the investment treaty regime. This regime is made of bilateral treaties that have, except for the Brazilian treaties that are very minority, there is no diplomatic element in the treaties. There's no discussion about where the members, the country, the parties that signed those treaties are meeting, are discussing questions. How can they all get together and issue such moratorium? There is no institution, there is no global organization with the jurisdiction to do that, you know. So of course it's going to be very difficult to implement such a thing, because what Pratyush was saying, it makes sense from a sort of formal point of view, but this means that every single country that has signed treaties, I don't know, I'm from Argentina, Argentina has ratified more than 50 countries, will have to negotiate with 50 people or 50 other countries at the same time. So it's a very difficult negotiation. This, of course, suits laboratories and the owners of intellectual property very well, because it means it's very difficult for countries to get to that consensus because we don't have the right institutions to do it. But we do have in trade and we do have in intellectual property. I am puzzled about this because if you read the Sustainable Development Goals, the 2030 Sustainable Development Goals, and you go through them, foreign investment seems to be key to reach and attain many of these goals. But we don't have the institutions to do it. We don't have the institutions for countries to sit down and talk about these things. For me, this is problematic. And I want to say, I don't think that if countries could discuss this in a global multilateral forum, this would be a panacea. As Federico was saying, the distribution of the vaccines is very unfair at the moment. But at least there will be a place where we could discuss this moratorium. At the moment, there's no such a place. And of course, this kind of, tilts the balance in favor of some actors and against others. Now, within this discussion, I think there is another thing to be said about COVID-19 and investment treaties. And I would be a little bit more optimistic. I wouldn't raise the alarm as the previous speakers did. It's a little bit like the other side of the mirror. Now, firms are saying, oh, you can make a lot of money by suing countries. And people are saying, oh, actually, if you look at ISDS practice, maybe they can win. Well, I think if you look at ISDS practice, I think it would be unlikely that an investment tribunal would decide against a case, against a state that implements measures that are globally labeled as okay. If let's say any country in the global south, that's what the WHO says it should be doing, then it will be unlikely that an investor would win. But in addition to that, we need to take into account the reputation element. For a laboratory at the moment to sue a global south country or even a global north country because of measures related to COVID-19 will have reputational consequences. It would not be good advertising. I mean, I do the parallel here, of course, with the fossil fuel companies. That maybe the parallel is wrong because I don't think there's an analogy between the two companies. But fossil fuel companies are a bit at the defensive at the moment, aren't they? And I should think that it would be the same for laboratories if they were like a very aggressive litigation strategy. Nonetheless, I think it's true to say that if global south countries want to get creative, if they want to pass measures that are more about, the production of generics, that are more about protecting patents less that are being protected in the north, if they are more about, trying to be sensitive to the needs of the people that sometimes are more are different from the needs in the north, that might create trouble. That's the area where I think, particularly institute like the Global South needs to be paying a lot of attention to. I think Carlos Correa in that regard is always, in the vanguard when he's been, he's saying, we know compulsory licenses look great, but they're very difficult to negotiate and you need to get an agreement also with the firms. A waiver would be better. And otherwise, if it's not a waiver, countries should go from national security exceptions that are in the TRIPS Article 73. And that's because if global south countries need to sit down with the firms to negotiate, maybe the negotiation would drag for long, and firms, of course, would prefer to keep keep protecting intellectual property rights as much as they can. So I would like to close on that note that we should not be so pessimistic about the prospect for global south countries and countries in all over the world to take measures related to address the COVID-19 pandemic. But we need to be attentive that if global south countries want to be creative, experimental, and to pass measures that take into account their specific situation, which normally is more unfortunately affected by poverty and the lack of maybe the same means as they are in the global north, then things can get a little bit trickier. Thank you.
Thank you, Nicolás. And with that, you wrapped up very well many of the messages that different panelists have made. We've run a little bit over time, just asking you if you could stay a few minutes with us more so that we close our panel. I'd like to ask the panelists if I can give you back each the floor for 30 seconds. If you could just, again, summarize one core message you think you'd like our participants to take away. In particular, there's a lot of interest with what can be actually done, considering that we're now in the COVID-19 pandemic, is this also an opportunity for pushing some of these changes, or at least more awareness of what can be done? So with that, I'd like to first give the floor back to Cynthia. Please, you have the floor.
Thank you very much. 30 seconds is a little challenging, but I would argue that in addition to dealing with COVID, this is a prime time to reconceptualize all of these agreements and possibly consider terminating them. That doesn't terminate all future claims, there's a window, but that is something that some countries are doing, and I think more countries should reconsider it, and whether we should even negotiate even more agreements when it's not clear it's actually helping developing countries with their goals.
Okay, great and very clear message. Now I'll give the floor to Federico.
Thank you, Viviana. I would like to emphasize in the relevance of the pharmaceutical sovereignty for developing nations, which enable them to enforce, to promote, to encourage industrial policy within their territories. Secondly, I think that we need to rethink the global rules of intellectual property to promote universal, prompt, and equitable access to medicine. And secondly, to reframe or to rethink in the investment treaties in order to promote proper development. Because one of the issues, and listening to Nicolás, I want to emphasize one topic, is that the investment treaty explicitly forbids the performance requirements for the developing countries, which of course deprives the developing countries of received technology which might be transferred for the of the developing world. So those are my three thoughts. Thank you, Vivian.
Great, thanks a lot. I'll go now to Pratyush.
Yeah, I think my one message will be, I think what investor can claim and what state, on what ground state can defend is based on the language of treaty. I think rightly Cynthia said, I think this is the best time to rethink the whole international investment agreement treaty making and drafting treaty in a way that there is a control of state in terms of defining the reach of investors. I think that is the way forward, I think.
Great, thank you. Alebe, to you.
Yeah, thank you. I think Vivian and I, we agree with Nicolás just said. I think it's also a prime time, it's also a great opportunity for countries really to rethink and remodel all these international investment agreements, because there's also a problem that it was affected like many countries, not only high income countries, but like middle and low income countries. So you have this awareness that like for global problems, we also need global solutions. And you have this awareness and it's also preparedness all to get into these conversations. And also going to what Nicolás said, like maybe even though that we don't really have like an international institution that could, let's say, wear the chapeau, the head of these whole discussions, but even like countries, they would go like bilaterally to their partners and try to negotiate like or rethink or refinish their agreements, because it's really, I think it brought a big awareness, and it might be, we see it's more like as a chance to keep momentum, like to reopen the negotiations, or even like when entering to new negotiations, really to think that public health, it must be a flexibility in all investment agreements.
Vivian, would you like to add?
I have nothing to add to Alebe. I completely agree. And I think the renegotiation of investment agreements have to be combined with flexibilities and a more precise language.
Great, so thank you to all the presenters. I think the challenge for all of us is really then how do we create more awareness of what we all seem to agree of those being present here. And that's the challenge, to support, in particular, the states of developing countries, and to also seek their own collective support for some of these initiatives, and to think where it's best to place them. And there can be many strategies. Of course, the IP waiver is one that has a lot of attention, so we can still see what can be done within the scope of that discussion. and that particular text, and then in parallel, look at all the venues where we should be bringing up these issues. So I'd just like to again thank you on behalf of the South Center, our Executive Director, Carlos Correa. Thanks a lot to Vitor also, who was our head behind putting everyone here together, who's also with us, although he's working on his PhD actually. And just to thank also all the participants for being with us, and we will be disseminating this as much as possible so that others can also follow in much more detail your presentations and great points. So thank you all very much. And if we can just quickly take a screenshot of everyone here before we all go. I'm just putting us in gallery view. So thank you all very much and have a great day.
Thank
Goodbye.
you.
Thank you so much,
Thank
Viviana.
you.
Vitor.
Have a good
Bye,
day.
Nicolás, Cynthia, Alebe.
Bye, everybody.
Vivian,
Nice
Pratyush.
to
Bye.
meet you. See you.
Bye, everybody. Bye.